Thomas Shukevich states as follows: if we're going to break the record of the longest ballot committee, we need everyone to sign up as soon as possible. We've already collected 100 nomination signatures for you. Now, just to be clear, that YouTube video has been removed by the longest ballot committee, correct?
That's correct. After our expose, they removed that.
The individual, the case was Kieran Shishkevich versus Canada in that particular case. Is there any relation between that Mr. Shishkevich and the one that testified here 2 days ago?
Sure, he's the brother of...
Okay. Would you be willing to table all the evidence and correspondence you have between yourself and your organization and the whistleblower so that we have that evidence, which I assume was part of the complaint that you filed to Elections Canada?
Certainly, and yes, it was.
Okay.
This guy's garage. Like and subscribe.
I'd like to welcome our first panel. First, David Muscrop, who is a political writer, and from Northern Perspectives, Ryan Davies. You will each have 5 minutes to deliver your opening remarks, and then we'll proceed with questions from all sides. So,
we first reported on the long ballot during the Toronto-St. Paul's by-election, but began a deeper investigation after the group publicly announced its plan to run more than 200 candidates in the Battle River Crowfoot by-election. What followed raised serious concerns about the integrity of the electoral process. In July, following our expose on the group's origins, we interviewed a verified LBC whistleblower and obtained internal communications, including text messages, emails, and organizer videos sent to LBC candidates. These materials, along with the group's own public posts, reveal 4 key findings. 1. The internal communications show a centralized direction, coordinated timelines, standardized messaging, and top-down instructions from organizers to participants, functioning in practice like a political party apparatus rather than a decentralized protest. I believe this is a direct violation of the Elections Canada Act, as they are operating as a registered political party despite not being registered. 2. Our evidence shows that organizers state they, quote, already have the signatures for participants who had not yet registered or even agreed to run. The communications we received from the whistleblower acknowledges that signatures were collected before organizers knew who the candidates would be. This is a clear violation of Section 67 of the Canada Elections Act and may amount to forgery under Section 366 of the Criminal Code. In his testimony on October 2nd, the Chief Electoral Officer confirmed that Elections Canada has seen the longest ballot committee submit blank forms in past elections and confirmed that the candidate name must be present. 3. Key internal messages state that there were no authorized delegates acting for specific candidates while signatures were being collected. Electors were asked to sign without a properly authorized representative of that candidate, as emails show organizers asking candidates to ensure they designate their delegate after signatures had been collected. This violates Section 67(4)A of the Elections Canada Act and constitutes impersonation under Section 480.1e. This was further corroborated by reports from volunteers for the Libertarian candidate, Michael Harris, during the Battle River Crowfoot by-election, who heard from electors that individuals had approached them falsely claiming to be collecting signatures on behalf of his party. 4. Separate from signatures, our investigation uncovered a substantial and sustained overlap between LBC and the Marxist-Leninist Party of Canada. LBC messaging, announcements, and narrative pieces regularly appeared on the MLPC's official website and social channels, with posts encouraging voters to support candidates of the longest ballot project. We could not find similar statements on any other social media platform, including the longest ballot committees. We invited the LBC to appear on air to discuss their conduct, but they refused the opportunity. One candidate initially agreed to an interview, but then withdrew after being told by organizers they were not allowed because the narrative could not be controlled. Shortly after our whistleblower episode aired, we then received a legal demand to remove all coverage of the longest ballot committee within 48 hours. We declined. We compiled our evidence package and emailed Elections Canada on July 25th, 2025 at 12:06 p.m. Eastern. To date, we have received no response. The longest ballot committee is not a protest. It is a coordinated campaign of mischief designed to make a mockery of our democratic process by violating the Charter 3 rights of Canadians across this country. Nothing more.
Thank you, Mr. Chair. Thank you to the witnesses. Mr. Davies, you testified, but you've interviewed and you've been in communication with a whistleblower who has been associated with the longest ballot committee. That whistleblower provided you with communications from the committee, including text messages, emails, as well as photographic evidence, correct?
That's correct.
Okay. Now, pursuant to the Canada Elections Act, in order to get onto the ballot, a candidate must receive the signatures of at least 100 electors endorsing their candidacy. Some of the text messages and email evidence from the committee indicates or evidences that the committee was collecting signatures from electors before they had candidates to collect signatures on behalf of in violation of the Canada Elections Act. Is that fair?
That's fair, and even some of the text messages that we have from the whistleblower confirm that they hadn't even started the process and were asking for help in order to navigate that process while the signatures were already in hand, as evidenced by the text messages.
Okay, so I'm going to go through some of the relevant text messages and emails, copies of which you provided to me. I have an email dated May 30th, 2024, a mass email, or it appears to be a mass email, sent out from the longest ballot committee. This was during the Toronto St. Paul's by-election. It reads, please excuse me, just throwing out the invite one last time. And then it goes on to say, we've collected the 100 nomination signatures you will need, and we'd love to have you, but certainly understand there are many, many, many good reasons not to participate in our crazy project. Just 3 more days till the deadline for candidate nomination arrives. Signed, Kieran Shukavich. So how is it that electors could have signed nomination forms endorsing candidates before the candidates themselves knew that they were candidates?
Well, and that's the whole question that we're asking, and that is why we try to raise awareness on this and email Elections Canada to ask about this, because if a candidate has not registered as a candidate and therefore has not authorized somebody as their delegate, how can you have that authorized delegate that hasn't been authorized to actually collect the signatures in the first place?
Well, precisely. And then I have another text message exchange between the whistleblower and Kieran Shukavich, dated August 16th, 2024, and during the LaSalle-Imard-Verdun by-election, in which the whistleblower writes, how many people so far going to break the record, as in going to break the record of candidates, to which Shukavich replies, it's 53 right now, probably 60 tomorrow. We collected signatures for 109, so it's possible we'll break 100, but it depends on who can get it all done in the next week. Fingers crossed. And then 2 days later, there was a video posted on the Longest Ballot Committee's YouTube channel of Thomas Shukavich, with the title below, the title of the video being message from the official agent. Now, I've watched the video, and Thomas Shukavich states as follows: if we're going to break the record of the longest ballot committee, we need everyone to sign up as soon as possible. We've already collected 100 nomination signatures for you. Now, just to be clear, that YouTube video has been removed by the longest ballot committee, correct?
That's correct. After expose, they removed that, and a lot of the other longest ballot organizers disappeared from social media.
Okay, very interesting. How convenient. And then there is a text message from, again, Kieran Shukavich, dated March 31st, 2025, in the context of the longest ballot committee recruiting candidates in the Carleton riding, in which he states to the whistleblower, I emailed you the nomination signatures and official agent form a few days ago. Now, you've talked to the whistleblower about his involvement in the longest ballot committee. According to the whistleblower, he had not indicated any interest in running for the longest ballot committee in Carleton, correct?
That's correct.
He was not involved in the longest ballot committee at that point.
That's correct, and evidence even shows that there's repeated attempts by Kieran to engage him over the course of several days and even the course of a week, trying to get him to say that, yes, I'm going to run, and there was no response by the whistleblower.
And yet the longest ballot committee here already had collected his signatures. How's that possible?
Well, and that's the whole point, and
Right.
It wasn't. And in fact, in Thomas Shukavich's testimony on Tuesday, he was even trying to say, well, we already know who's interested, and then that's how we know how to collect the signatures. But if they haven't registered as the candidate, and there's even another email that we have that specifically is from the longest ballot committee to the whistleblower asking him to, don't forget to assign Thomas as your delegate as soon as possible. But in the same email, they say they already have the signatures. So one cannot happen without the other if you're playing by the rules.
Okay, well, Mr. Chair, this evidence is very disturbing. It raises serious questions about whether the longest ballot committee collected invalid signatures, which in turn raises the question, how many candidates connected with the longest ballot committee have appeared on the ballot who should not have because they didn't have the requisite valid 100 signatures as required by the Canada Elections Act, and it raises further questions about whether the longest ballot committee broke the law.
Very brief response. We're at.
I would just say it's when you look at the scale of how many candidates that the longest ballot has actually engaged with since they started back in 2019, and you multiply this procedure, if they've been following it every single time for every single candidate, you have hundreds of violations of the Elections Canada Act, and potentially that compounds because it could be impersonation, it could be obstruction, and depending on how the Criminal Justice Code interprets it, it could be amounting to forgery as well.
Okay, thank you, Mr. Davies. You can elaborate with further questions. Mr. Wilkinson.
We had Dr. Turnbull here on Tuesday, who talked about her perspective that in order to restrict the freedom of citizens to engage the electoral process, it's a high bar. And that even if it's annoying, one has to actually be clear that there are either impacts or significant potential impacts associated with the actions of folks like the Long Ballot Committee. So you touched on this in your comments, but the long-term impacts or the potential impacts of this on a widespread basis, how significant do you think those would be? Did they rise to that level of looking to restrict them? And if so, what would your prescription be for addressing it?
So, I mean, I think it's necessary to study this, and I'm glad you're studying it. I also think it's necessary not to blow it out of proportion. We've got a world in which we're facing a number of serious problems, and we shouldn't pretend that the longest ballot committee is going to destroy Canadian elections and make it impossible for folks to run and get elected. The fact is the vast majority of people who run with parties, and if you're going to win, you're likely to be with the party. The problem is the long-term kind of chipping away at the quality of our elections, the trust in our elections, making life more difficult for the people who make the elections in this country possible, because frankly, we have one of the best electoral machines in this country has one of the best electoral machines in the world. We run the best elections in the world. We run them with a piece of paper and a writing implement, and volunteers or part-time or full-time temporary workers who have other things that they do, and we should preserve that. We should work very hard to preserve that. So I don't worry that the longest ballot folks are going to destroy Canadian elections, but I do worry that if it gets scaled up or persists over time, it's going to start to add up and create problems. As for prescriptions, I was listening to the testimony from Dr. Turnbull, among others, and I was just thinking, look, there's a few sensible things. One, I thought you couldn't have one person be an agent for more than one candidate. It was absurd to me that was the case. That seems like an extraordinary oversight on the part of the regulation in the first place. So that's a gimme, I think. The other is, look, whether it's 100 unique signatures or it's maybe perhaps you can sign 3 to 5. I do think there needs to be a little bit more grit. I think it's reasonable to have a little bit more grit to get onto the ballot to prevent stunts like this, because I do think it's a protest, but I also think it's a stunt. And I think on the one hand, it needs to be corrected to preserve trust long term, but we shouldn't overreact because in a sense, if we end up overreacting, the cure is going to be a little bit worse than the ailment.
So my question is to both of you. Do you believe that with all that we've discovered about the longest ballot committee and the violations of the Elections Act that they involved, is there any possibility that the movement dies out by itself because fewer people will be tempted to take part in a move like this if they knew they would be violating the Elections Act?
I mentioned forbearance earlier, and I'll tell you, I was thinking about this yesterday walking around. Like, I'm going to think about this as a democratic theorist. I'm going to think about this as a journalist. I'm going to think about this as a citizen of this country. I'm going to think about this as someone who actually supports electoral reform. What's the best outcome here? And the best outcome is they stop. They take the message. They exercise some forbearance. And they say, you know what? This isn't working. In fact, it's doing harm to our elections, but also to their stated goals. Let's try something else. Let's move on. And then perhaps the Parliament could look at small legislative changes to make it slightly less likely this happens in the future. But honest to God, I think the best answer is they stop. And I know they'll be seeing this, and I certainly hope they take that message to heart, because it's not doing us any good.
And what I would say is we've done a lot of monitoring of the long ballot social media, and they've been monitoring these committee meetings. They were monitoring the committee meetings last fall, and they have heard all these suggestions, and on their own social media, they're posting, don't worry, no matter what they do, we're going to continue. So they seem intent on this, and I think that's evidence back from the original court decision in Alberta of 2017, where the lead organizer, Kieran, tried to have all of the restrictions to register as a candidate to vote wiped away. And luckily, the Judge Inglis ended up only striking down the $1,000 bond.
Une autre question. Avec la loi électorale.
One further question. With the Elections Act as it is now, do you think there's a way, rather than amending it, to apply it more effectively to prevent this from happening again or continuing?
Signature checking. I mean, I did listen to the testimony previously and hear that some candidates, the returning officer rejected something. So there was a check and balance there at some point. But here's the thing. If there are problems with signatures, that needs to be caught before a candidate is on the ballot. If it's caught after the fact, then we're talking about consequences for that, but the damage to some extent to the public good is already done. So if people are sneaking onto the ballot that ought not to be there, that's the problem. And now we don't need to talk about checking these things a priori. Incidentally, if we can't control signatures now, if we're going to introduce further restrictions on signatures or requirements, we need to be sure we're ready to actually check them. We can't say, well, we'll let Elections Canada figure it out later. And this comes at a time when the country is looking at reducing budgets. So there's also a budgetary concern, as if we're going to spend money, are people going to be ready to spend this money to do it? So I would say, before we start looking at making things tougher, make sure you can actually enforce the regulations you have currently on the books.
And I would say, I agree, money is going to be the issue here. The issue with the Elections Canada Act as it is right now is I look at this from a process architecture perspective, where this is just a big process on how to run an election. However, I don't see any controls in place for this process. So you can say that a candidate or person who must be who is authorized to act on a candidate's behalf, that is a requirement. I don't see any way to enforce that. Where's the control for that? And there's many other examples in the Elections Canada Act where that's the case. And the Chief Electoral Officer even admitted that they don't have the resources to even implement any controls to check the Act as is.
Merci. Est-ce qu'on risque pas, si on essaie...
If we keep trying to correct things, don't we risk encouraging someone like the Longest Ballot Committee to find every possible loophole in the legislation, and that turns into a cat and mouse game?
There's, as we heard from Mr. Davies a second ago, if the committee decides to keep the Longest Ballot Committee to keep going and going and going in different iterations, it's going to be whack-a-mole. And we're all going to be back here in 18 months, or maybe that's too soon, 2.5 to 4 years doing this again. And then again and again and again. And meanwhile, there are serious problems at scale about the misinformation, disinformation environment, the health of our democracy, and so on at some point. Which is why I keep saying that often the best solution is forbearance. But if that's impossible, then it's going to invite, and this is why I keep saying, it's going to invite a response that works against the outcomes that the Longest Ballot Committee wants. It's going to make life more difficult for people to engage in electoral democracy. It's going to make people less inclined to want proportional representation. I'm less inclined to want it. I've been fighting for it for 15 years. I wake up thinking, God, it's getting hard to go to bat for this. Yeah. So I hope that they take this seriously, because I think there's a very serious problem, and the last thing we need is a game of whack-a-mole right now.
Merci beaucoup, Madame Normandin. We will go on to Mr. Culkins for 5 minutes, please.
Thank you very much, Chair. Mr. Davies, in your opening testimony, you appeared to be, well, you were very clear in what you surmised to be happening here based on the information that you have. Could you elaborate a little bit more on why you think the Longest Ballot Committee is actually operating as a political party rather than as a protest group?
Well, you just have to look at your own political parties, and it doesn't matter which one you're a part of, Liberal, Bloc, NDP, Green, PPC, what have you. If someone wants to know more about your party, where do they go? They go to your centralized party website where you have all of your media. And the Longest Ballot, they were centralized on X, and now they're centralized on Blue Sky. Most of their media isn't there. They have random social media posts they put up there, but all of their formalized statements, political statements, and formal responses to even committee meetings, statements by the Chief Electoral Officer, they're all posted on the Marxist-Leninist Party website. So there's that. So they formalize all of that into one specific website. But where it really comes into play is they operate as if they're a political apparatus. They're talking to their candidates as if they're running across the country, but they're not. They're running in one riding. They give them all one direction. They're running under a single platform. They are...
Just to be clear, a political entity is only allowed to have one candidate on the ballot in each constituency. Is that correct?
That's correct.
So you believe that because they're either committing an offense by running more than one candidate, or they're failing to register as a party. Is that correct?
Correct. The main crux of it is a registered party is only allowed to run one candidate per riding. So they get around this by not being "quote unquote" registered. But
do you think a legitimate candidate gets 0, 1, or 2 votes in an election?
I think a legitimate candidate would be embarrassed to get that amount.
Interestingly, I've been personally quite frustrated since 2017 with the decision by a court in Alberta, which ironically, the witness that was here on behalf of the Longest Ballot Committee is suggesting that people outside of Parliament should be making rules. So here we've had a rule made by a judge in Alberta in 2017, somebody who's not a politician and has never likely run for it, appears to have no political experience whatsoever, has now made a decision to remove the $1,000 bond. I've often thought it was a mistake by the government at the time to not appeal that decision. Can you tell me more? The individual, the case was Kieran Shishkevich versus Canada in that particular case. Is there any relation between that Mr. Shishkevich and the one that testified here 2 days ago?
Sure, he's the brother of Thomas Shishkevich, and the biggest thing that jumped out at me in this decision is actually paragraph 23, where it says the applicant submits that while the deposit requirement is allegedly an attempt to deter frivolous candidates, it may well deter non-frivolous candidates who are not affluent. So,
does the Longest Ballot Committee, in your opinion, have anything but frivolous candidates?
No.
Do you think that, so obviously from my perspective, this appears to be a well-orchestrated campaign that started well before and they knew that they would have to get that $1,000 bond removed, and actually were prepared to go to court. What does that suggest to you about political motivations and the actions of an actual political party?
Well, given the fact that they're trying to get all of the requirements removed, this seems to be a well-thought-out, orchestrated attempt to engage in this behavior in the first place. Because after he won this court challenge, did he run in the election? Not as a legitimate candidate. All of a sudden he teams up with the Ryan Osser's party and they start running these long ballots. And the biggest thing about this court challenge is this was him saying this is violating his Charter 3 rights. But now they're going on to violate the Charter 3 rights of people with disabilities and seniors across this country. And for people to say that this is a small issue, it is not. This is an issue that our forefathers fought for. And we need to take that seriously.
Couldn't agree with you more. With all of the information that you have from the whistleblower, plus everything that we know in the public domain, is there anything that leads you to believe that the longest ballot committee is actually just a protest, or are they operating with clear and decisive intent?
I think the fact that they couldn't even answer the chair's question about, okay, fine, let's accept that this is a protest. What's your solution? And they don't even have a thought-out solution, and then they've been doing this for 6 years. They haven't thought about that at all. This shows that they're not serious about an actual resolution, and this is just malicious intent.
Do you think
Thank you so much,
thank you,
Mr.
Chair.
Calkins. I did cut you off with 3 seconds left. I do
All right.
apologize. I'll give you 3 seconds more the next time.
Just building on what you're talking about and the questions that my colleagues asking around the influences. You said that in your opening comments that most information that Canadians are consuming right now is coming from influencers online, more so than they're getting from official channels of elected officials or even Elections Canada. I'm actually curious to know how you think we manage that, and where do governments play a role in regulating misinformation, because a lot of information is not factual. It can be tracked, it can be true, and a lot of actors that are foreign can be using those influencers to pass massive information that is probably not true, and what it does to our electorate and our democracy. Can you talk a little bit about what our role would be in managing that without partisanship or censorship?
It's a very easy question. We'll be out of here by next week. That, to me, is the primary question for the future of good political decision-making and democracy is how do you manage information so people have good information and can make good decisions? And you indicated, I think, the core challenge, which is at some level, we want to be able to control what's out there. But the state shouldn't be adjudicating truth or fact, for that matter, unless we're talking about labels on products. That's one thing. But when it comes to democracy, we're making value statements, we're making judgments, and I'm very nervous when the state starts deciding what is fit to pass as a judgment and what's not, because that's going to be inherently subjective and based on values that may not be universally shared in this country. So I come back to the argument of, okay, well, we want to maximize the information Canadians have so that if something is on the internet, you should have a reasonable expectation that you're getting what you think you're getting. If it's AI created, for instance, I'd like to know it's AI created. It's becoming increasingly difficult to know that. But what if it's just partially AI created? How do we do that? I don't know. But so there's at least at the theoretical level, you want to be able to know what you're consuming, but then you want to have the capacity as an individual to navigate that as an individual, as not as the state doing that work for you, but you as an educated person. And so at the one hand, we need to make sure we're educating people to navigate these spaces, but also incentivizing them to do the work. Because I'll close on this point. Let's ask ourselves how people consume this stuff. Maybe they're walking around. Maybe they're watching the ball game in the background. Maybe they're playing a video game. Maybe they're on the bus. When people are consuming things, they're not necessarily sitting down and thinking, I'm really going to dig into what I'm watching now. It's white noise.
Thank you, Chair, and thank you, gentlemen, for being here today. Just like to start with Mr. Davies, a couple of questions. You mentioned earlier in your testimony that you or your organization filed a complaint with Elections Canada regarding the Longest Ballot Committee's actions. Can you just make it very clear on the record who specifically you submitted that claim or that complaint to?
So we initially contacted Elections Canada by phone to ask them how to report this, and then they provided, I believe it was the email address, info@electionscanada.ca. That's the mailbox we were advised to send it to.
And to date, you have received no response to that. Is that correct?
Correct.
Okay. Would you be willing to table all the evidence and correspondence you have between yourself and your organization and the whistleblower so that we have that evidence, which I assume was part of the complaint that you filed to Elections Canada?
Certainly, and yes, it was.
Okay. Thank you very much. Just now to Mr. or Dr. Moskrip, I want to thank you for your testimony today. I was going back and forth a little bit with Dr. Turnbull on Tuesday because, and I'll read, I know you watched it, but just what I said was just to summarize that I agree, and I agree again with what you said, that we've probably given this farce too much airtime that only they have gotten excited about. That being said, I do think we have to come to an outcome here. I don't think this can go on. And so to summarize her position, I asked her that she did not support the restriction of signatures to only being able to sign one candidate's paper, but that she would support a change such as one official agent can only be the agent for one candidate. She said absolutely on the official agent piece, and she said that she wished we didn't have to do the piece about the candidate signatures, but unfortunately that's where we are. And so she actually ended up agreeing with both those solutions. What is your perspective on that? Would you find yourself in a similar place?
Oh, absolutely. Here's the thing. If there are reasonable and unreasonable barriers to running. I think financial barriers can be unreasonable. I think old shoe leather barriers, as in go get signatures, go knock doors, go prove that you're serious, are utterly reasonable. Again, I was stunned that you could have one individual act as an official agent for more than one person. It is on the face absurd, and incidentally, a conflict of interest. Right? I mean, one of the premises of the longest ballot is that politicians are in a conflict of interest. Okay, well, apply the same standard to what you're doing. Using one agent for 100 people or 191 people, also a conflict of interest. It's inconsistent. So on the one hand, so yes. On signatures, yeah, I think if you have to get a handful, 100, whatever signatures it might be, fine. Unique, I did notice the witnesses brought up the point of, look, if you're an elector, you might want to sign 2 or 3 people's forms. Maybe you haven't decided who you're going to vote for yet. I've gone back and forth in a couple elections. People change their mind. But 191? That's obviously against the spirit of the law. So I think it would be reasonable to have a limit of that of some sort. Because here's the thing: if you can't get 100 unique signatures, are you a serious candidate? I mean, I could get 100 unique signatures when I ran for student council president.
Right.
2-termer, by the way. But in a high school of 1,200 people, you can get 100 unique signatures.
Yeah. Okay, thank you. I appreciate the clarity on that because I do think this committee will need to take the expert advice as to an outcome when we get to the conclusion of this study to ensure, a balanced approach, but certainly a swift one in ensuring that future by-elections, this is in place so that this farce doesn't continue any longer. So I certainly appreciate that. I wonder your perspective on the number of signatures overall that are required. The number is 100 right now. We know in previous Parliament, the government, the Liberal government, actually brought forward a bill to reduce that number of required signatures. I believe it was down to 75. Just wondering if you have a perspective on that, whether you think that's appropriate or wrong-headed given this longest ballot committee and just the general context overall.
I mean, I think it's the difference between, to use a contemporary reference, winning a ball game 6-1 and 7-1. Whether it's 100 signatures or 75 signatures, I don't think there's a material difference there. Because if you can get 75, you can probably get 100. Now, can you get 1,000? That's unreasonable. It's really a matter of scale. So I don't think there's any real pressing. I don't think it's worth the paper you'd have to print it on to reduce it to 75. Really?
Yeah.
Right? I mean, it's just I think it's a show. It's more of a gesture than it would be a substantive change. Ditto raising it to 125. The 100 is entirely reasonable, but I don't see why you would lower it. Unless you're going to lower it to 0, and then you're having a philosophical debate, not a regulatory debate.
Right. Do you have any further perspective on Mr. Davies' commentary about the longest ballot committee, rather than a protest movement, operating as either a political party or a third party, which has been suggested as well in previous conversations, that this is a centrally organized group of a very small number of individuals who are giving central direction to sometimes not even full candidates yet, we've heard in testimony, people who are prospective candidates, and whether they should be governed in some way by either the rules that govern third parties in our elections or the rules that govern political parties in our elections.
Very brief answer, Dr.
I hadn't thought about it until Mr. Davies brought it up, but I found his argument cogent. And again, I'll go back to this. We have effectively an exploitation of loopholes in the law right now that are in violation of the spirit of the law. And I think Mr. Davies made quite a cogent argument.
Thank you so much.